This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today I'd like to speak about why an employee cannot sue his or her employer for negligence, and that proof of an insurance endorsement does not change the policy exclusion for injuries to an employee. Joshua Ochoa sued his employer, Riata Cattle Company, in Texas State Court, alleging that he suffered bodily injury when Riata's truck, which he was driving, malfunctioned and crashed due to Riata's failure to repair and maintain it. Ochoa claimed an endorsement required by state statute eliminated the employee exclusion. In National Liability and Fire Insurance Company versus Riata Cattle Company, the United States Court of Appeal for the Fifth Circuit on December 21, 2022, resolved the dispute. The insurance coverage dispute arose from a single vehicle accident that led to a lawsuit by Joshua Ochoa against his employer, Riata Cattle Company, Inc. Ochoa sued Riata in Texas State Court, alleging that he suffered bodily injury when Riata's truck, which he was driving, malfunctioned and crashed due to Riata's failure to repair and maintain it. Ochoa also alleged that Riata committed negligence and gross negligence by failing to provide him with safe equipment, failing to warn him of any dangers, failing to inspect and repair the equipment, and other negligence theories. Riata sought coverage defense from its auto liability insurer, National Liability and Fire Insurance Company, which is currently defending Riata in the underlying litigation under a reservation of rights letter. National Liability sued, seeking declaratory judgment that asks for a determination that it owes Riata neither a defense nor indemnity under the insurance policy. National Liability contends it is entitled to a declaratory judgment because the policy excludes coverage for employees of Riata. Ochoa seemed to concede the argument, but contends that the Form F endorsement on the policy compels National Liability to defend and indemnify Riata. The district court made two rulings. One, the policy provides an exclusion with regard to the lawsuit brought by Riata's employee Ochoa, and two, the Form F endorsement does not change that exclusion. The district court came to this conclusion because it couldn't be clearer in the insurance policy that the employee is not covered. Close quote. The policy provided that under the exclusion section, coverage does not apply to an employee of the insured arising out of any course of employment by the insured or performing the duties related to the conduct of the insured's business. An employee included a leased worker, but did not include a temporary worker. A leased worker is not relevant for the case, and a temporary worker is defined as a person who is furnished to you to substitute for a permanent employee or on leave or to meet seasonal or short-term workload conditions. Ochoa didn't fit those definitions because Ochoa alleged he was working in the course and scope of his employment with defendant when he sustained serious and permanent injuries when the tractor-trailer rig defendant owned and provided to plaintiff to drive malfunctioned and caused a crash. Therefore, it was undisputed that Ochoa was Riata's employee, and Riata is excluded from coverage under the policy. Riata contended that the finding that Ochoa is its employee is not the end of the analysis. Specifically, Riata claimed that the Form F endorsement overrode exclusions in the underlying policy to provide an independent duty to defend. Form F provides, in part, quote, the certification of the policy as proof of financial responsibility under the provisions of any state motor carrier law or regulation promulgated by any state commission having jurisdiction with respect thereto amends the policy to provide insurance for automobile bodily injury and property damage liability in accordance with the provisions of such law or regulations to the extent of the coverage and limits of liability required thereby, provided only that the insured agrees to reimburse the company for any payment made by the company which it would not have been obligated to make under the terms of the policy except by reason of the obligation assumed in making such a certification. Form F is a statutorily required proof of insurance set forth by Texas Transportation Code Section 643.103. On its face, Form F does not guarantee anything. It exists only to certify the policy is required by applicable regulations. The Texas Transportation Code, Section 643.103, provides that, quote, a motor carrier that is required to register under Subchapter B must file with the Texas Department of Motor Vehicles evidence of insurance or evidence of financial responsibility in a form prescribed by the Texas Department of Motor Vehicles, close quote. The form prescribed refers to Texas Transportation Code Section 643.051, which provides in part that a motor carrier may not operate a commercial motor vehicle on a road or highway of this state unless the carrier registers with the Texas Department of Motor Vehicles under this subchapter, close quote. These regulations require insurers to file Form F with the Texas Department of Motor Vehicles. Under Texas law, Form F, quote, protects third parties against the possibility that a motor carrier will be underinsured with regard to the requirements of state or federal law, close quote. And those regulations which are designed to protect the public are different and distinct from regulations that protect employees. As the district court noted, there is a difference between the public as opposed to an employee, who are excluded in the insurance contract to begin with. The purpose of state compulsory insurance laws and Form F is to protect members of the public who have been injured by the negligent act of a motor carrier, even if the vehicle involved is in an accident is not covered under the motor carrier's insurance policy. Form F has no effect on the validity of the employee exclusion in the policy, where the employer was not required by state law to obtain workers' compensation insurance or where workers' compensation was otherwise not available. Insurance contract endorsements frequently modify the terms of an insurance policy, but this is not the scenario here. Rather, Form F is a boilerplate endorsement filed with the Texas Department of Motor Vehicles, and it serves as a guarantee to the public that the insurer will be liable for damages awarded if the insured is unable to pay. Form F exists to ensure the liability insurance is always available for the protection of motorists injured by commercial motor carriers. Employees are not considered members of the public for the purpose of Form F. Therefore, Form F does not save Riata's claims for coverage under the policy. Since Ochoa was an employee of Riata, and according to the applicable policy, national liability is excluded from providing insurance coverage to Riata for the underlying litigation, and Form F does not change the employee exclusion in the policy. In my opinion, Ochoa and his counsel were creative in arguing that Form F changed the policy. It just didn't work because Form F was designed to protect members of the public, not employees who should be entitled to workers' compensation if they were injured in the course and scope of their employment. Creativity deserves acknowledgement, but not necessarily success. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog, where you can read it and more than 4,400 blog posts on insurance coverage issues. It's also available as a video on rumble.com and on youtube.com. And if you watch it on either service, please click on the Rumble button or the like button. And please, if you found this video to be interesting or useful to you, tell your friends and colleagues so that they can also subscribe to the blog or to the videos. And you might also wish to consider becoming a member of my locals community or viewing my Substack publications, where for a small additional fee you can see extensive information for those involved in insurance and insurance claims. Thank you for your attention.